The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be searched. That's the Fourth Amendment to the Constitution, and very simply it's the answer to the overarching question, is NSA spying legal? Clearly it's not. I borrowed a few comments from Senator Ron Wyden speaking on the extension of FISA and the Patriot Act reauthorization, because they spell things out quite simply. Looking back, American colonists were subjected to taxes by the British government. They thought it was unfair, and so they smuggled some goods, tea, paper, to avoid paying taxes. And as a result, the authorities began issuing general warrants called writs of assistance. They authorized government officials to enter any house or building to look for smuggled goods. They weren't limited in searching certain houses, and they didn't have to show any evidence that the place they were searching might have smuggled goods. Obviously, if you let the government search any house they want, they're going to look through houses of many people who haven't broken any laws at all. When King George II died and authorities had to get new writs, colonists tried to challenge them in court. James Otis in Boston denounced the mass invasion of privacy and described the writs as, quote, a power that places the liberty of every man in the hands of every petty officer. So the country's founders made sure to address this in the Bill of Rights. They included protections for personal privacy in the Fourth Amendment, saying the government does not have the right to search any house it wants, even if it helps them do their job. Government officials may only search a house if they have evidence someone is breaking a law, and they show that evidence to a judge to get an independent individual warrant. NSA spying is evidently being justified under the USA Patriot Act and the FISA Amendments Act of 2008. That was a successor to the warrantless wiretapping under the Bush administration. It gave government authorities new capacity to collect communications of foreigners outside of the United States. But it was subject to secret government interpretations, unknown to us, the public, and unknown, it seems, to many in Congress. And those interpretations are being used now to justify broad-based surveillance of Americans, of our communications now and ones going forward that may happen electronically. With technology, the founders could not have imagined the extent of this kind of broad-based search. When FISA was written originally in 1978, Congress applied the same principle to intelligence gathering. The original FISA statute says if the government wants to collect an American's communications for intelligence purposes, it must go to a court, show evidence the person is a terrorist or a spy, and get an individual warrant. It upheld the same principle the Founding Fathers fought for in the Revolution. In 2008, Congress passed the FISA Amendments Act, replacing the warrantless wiretapping program with new wide government authorities to collect phone calls and emails of people believed to be foreigners outside the U.S. The centerpiece of the FISA Amendments Act is a provision, now Section 702 of the FISA statute. Section 702 does not involve getting individual warrants. The government can get programmatic warrants that last up to a year and authorize the government to collect, as we have seen, a potentially vast amount of phone calls or emails. There is no requirement that the senders be involved in terrorism or espionage. It's very much like those early general warrants that allowed government officials to decide whose privacy to invade. For this reason, Section 702 contains language specifically intended to limit the government's ability to use warrants. But it doesn't actually prohibit them from collecting our phone calls without a warrant. It says they can't intentionally target a specific American or intentionally acquire communications, but that's the loophole that apparently they've been using to do broad-based searches. Colonists, compared to us, could challenge general warrants in open court. I'm sure many of you know that organizations such as the Center for Constitutional Rights, the Electronic Frontier Foundation, the ACLU, and others challenged the Bush warrantless wiretapping program. In each case, they were told they didn't have standing, and they couldn't prove with certainty that they were being wiretapped. We know that that creates what's called a chilling effect on free speech. If you're aware of the possibility that your conversations and correspondences may be monitored, it affects the way you communicate. If the FISA court were to hold open debates the way they did when James Otis and John Adams publicly debated whether the laws were protecting privacy, in the age of digital communications, it could conceivably pass unnoticed by the public, even by those whose privacy was being invaded. We have a government that's cloaked in secrecy. And as you can see by the whistleblowers and leakers that we so honor and owe a debt of gratitude to, information is carefully being guarded and led to sift out according to what message the Obama administration wants to send us. In 2009, Obama wrote to Senators Rockefeller and Wyden to inform them they would be setting up a process for redacting and releasing FISA court opinions that contain significant interpretations of the law. But that process has produced virtually no results. Not a single redacted opinion or summary of FISA court rulings has been released. I think it's important when people say, I'm not doing anything wrong, I have nothing to worry about, that you remind them that if we don't exercise our hard-fought First Amendment rights and Fourth Amendment protections that were designed to shield us from an overreaching government, and not the other way around, that our democracy is indeed very imperiled. Thank you.